Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna PC, immigration.com. Today is February 20th, 2014. This is a community conference call, which we do every other Thursday. By participating in this call, an attorney-client relationship is not intended to be established, as you would have heard from the recording when you logged in. That said, let me get started right away. I think we're going to have enough time for new questions. But first I will answer the questions as usual, as we always do. I'll answer the questions that have been already posted. Then I will take follow-ups on those, and then we will take new questions. First question is from Sunil Benjamin, whose child is born in the United States, but he wants to keep Indian citizenship. So, actually, Sunil, this is the first time I've been asked this question. You think that this is a common issue? It probably is not. So, as far as the possibilities of advantages and disadvantages, I don't know if I can give you a detailed explanation of what the advantage of any particular citizenship is. As far as I know, just because the child becomes a US citizen, they do not lose their American citizenship, which they have acquired by birth. So, you're welcome to go ahead and keep an Indian passport. Apply for an H4. Probably the USCIS will not have a problem if they don't catch the fact that the child is born in the United States. If the child is born in the United States, then you might have an issue and they wouldn't know how to deal with it. It would become a lot more complicated because, as far as I know, the child cannot reject their citizenship until they turn 18. But again, I'm speaking from just general knowledge, which is not a good idea. In law, things can be very, very specific. Making some guesses here. But if I were you, what I would do is get the Indian passport, which you're doing, and then apply for an H4 using form I-539. Let's see how it goes. Okay. Next question is from Arjun, who wants to know about H-1B transfer and green card. Currently working for company A, got an offer from company B. Wants to have company B file premium petition for the H-1B transfer. What if I don't join that company? Will it have any impact? And the answer is, under immigration law, no. But can the company B sue you for expenses or any contracts that they have signed? Probably. But that's a matter of state law. Under immigration law, there is no problem. Okay. Company A, I-140 is approved, waiting for priority date to be current. If I get an offer from company B, I would like the company B to file a premium petition. Once the H-1B transfer is approved, I'll join company B. What's common practice? Will company A cancel my green card per I-140? Yes, they should. It isn't common practice, but any clients that we work with, any corporate clients, we do recommend that they revoke the I-140 once the employee leaves, because that makes it easier for them to demonstrate ability to pay wages for other employees who are still on their payroll. Okay, so general answer, they should do it. That's the better practice. A lot of employers don't do it. It is not required by law to cancel the I-140 once an employee leaves. H-1 they have to. I-140 they don't have to. And your last question is, in order to cancel the green card filing, does the company have to file a petition and pay money? And the answer is no. It's just a letter. Next question, OGL 2014 wants to know, if I'm an EB-1B, which is outstanding researcher or professor, and if I leave very soon after getting a green card, does that violate the requirement to work permanently? And you've done some research on this. I haven't. I cannot answer this question off the top of my head. But the usual rule is this. And I don't know how it would specifically apply to EB-1B people or EB-1-2 people. I would have to review my notes and the regulations. But the general rule is, because of the advent of AC-21, I think this requirement of working permanently has been considerably diluted. It was already not a very strict requirement. As long as on the date you received your green card approval, you still had the intention to work at that place indefinitely, your green card was always beyond challenge. If 10 days down the line or 15 days down the line you change your mind, that's okay. So first of all, it was always a very loose requirement, very easily countered, especially so when green cards were taking so long, and then especially so after that because of the AC-21 law. So I don't view this as a very major hurdle, but of course, wherever possible, we don't want to argue with the government. We want to avoid any kind of gray areas if we can. Personally, I don't think it's going to be a problem if you leave after a few weeks. Optimist wants to know, I've been in the US on L2 for 4 years, working on EAD for the last 1 year. Husband's L1B will be expiring in Feb 2015, which is 5 years. Our visas are valid till 2018, but 797 only 2015. His company will be filing for transfer from L1B to L1A, so he can get another 2 years. Employer will be filing H1B in April 2014. If I get my H1 approved, does my L2 become invalid? And the answer is, that depends. If you apply for change of status, then on October 1st, 2014, you will be converted to H1, not L2. If for whatever reason I want to transfer back from H1 to L2, then what is the procedure? You can do one of the two things. Go outside USA, re-enter using your L2 visa, or apply for a change of status back to L2 using Form I-539. If on the other hand, your H1 was approved without change of status, then you are already on L2, you don't have to do anything. Okay. Pooja, I think I've answered those questions. If you're on the phone, any follow-ups, let me know. Baldwin, currently last semester of undergraduate study, applied for a change of status from H4 to F1 in December 2013 and still waiting. Eligibility for OPT is 1 academic year on F1. Can I apply for OPT counting fall 2013? Any time that you were on H4 will not be counted. Okay. So Sam, the requirement is F1 status for 1 academic year. I believe the exact language, and I could be wrong about this, I think the exact language is 1 academic year. Okay. Mine 2012 is from Yemen. Visa category is F3. Case is current on August 2013. When will be the case forwarded to the US Embassy in Sana'a? What you can do is you can follow up with National Visa Center. National Visa Center, they actually have an email address. If you just Google National Visa Center in New Hampshire, they'll be able to at least give you some idea of where they are. Erica wants to know, she had applied for a green card for her husband who's in the country illegally, but even after the I-130 approval, the 485 was denied. He was given 10-year bar. They have never received a deportation notice. What can we do? Erica, this is a difficult case for me to answer. It appears to me that your husband is not eligible to receive an adjustment of status. I don't know what the reason is. Is it because he entered USA illegally without inspection? I do not know what the detailed reasons are, nor can I guess. I would certainly recommend you get a second opinion from another lawyer, and preferably not from us, but go to a lawyer who does deportations, because there may be some possibility of some kind of relief in removal or deportation proceedings that could help you. So speak with a lawyer who does deportation work, and you might be able to come up with something in addition to what you have already told me. Doesn't hurt to get a second opinion, okay? UK bound. I'm a little confused by this fact pattern. What has happened here is, um, I live in the US, my fiance lives in UK and is a UK citizen. Plan is to eventually be married and live in the UK and provide financial support for both of us. Fiance has a past criminal record from 25 years ago, B&E, which I'm assuming means breaking and entering. He may be losing his job. I live in the US, I have a part-time job. Plan A, fly to Greece and get married. I return home and apply for a spousal visa. I'm not sure which country are you talking about. Are you talking about a spousal visa for UK? If so, you need to talk with a lawyer who practices in the United Kingdom. We practice only on the US side. But if you wanted to apply for a spousal visa, and I don't know whether you mean a green card or a K3, both of which are possible and both can be done together. K3 and green card. Okay. I am not sure what the breaking and entry what kind of effect would it have. That's something that needs to be looked at. It can be a complicated issue. And what kind of waivers are available. So we'll have to have somebody check that out. If I apply for fiancé visa, fly to the UK, get married and live there, again, I think you're talking about UK visas. Go to Canada and get married, he returns to the UK and I return to USA. I don't see any problem with it. Okay. Again, I do not know what the Canadian immigration laws are. So I'm not sure I can really do much for you, ma'am. If you are on the telephone, I'll be happy to speak with you. But it doesn't look like you're asking me any questions about US laws. Arpit Shah says, my I-140 got approved on April 2012 with Company A. Applied for 485 immediately, got EAD, done fingerprinting. In December 2012, joined Company B after 180 days with Company A. In June 2013, Company A informed USCIS that I did not complete 180 days after my I-140. By the way, that's not a requirement. Okay, got a query on my 485 asking to provide proof that I worked in Company A. Okay, so you also got your I-140 revoked. I-485 query response is still pending. Does it mean my 485 will get rejected? And I don't think so. I don't think so. Okay. If you have filed AC-21, a letter with the government, it should not be a problem. I don't see any reason for rejection so far. I think you should file an AC-21 letter. I'm not sure if you've done that. That would be a very good idea. Okay. And I really don't know, Mr. Shah, the details of your case other than what you've told me, so it's difficult for me to judge. But typically, if there is a query on the 485 and you are eligible for AC-21 portability, which you are, it looks like, your 485 cannot be rejected even if the I-140 is revoked, unless the I-140 is revoked by USCIS for fraud or misrepresentation. Okay? So, it looks to me you should be safe, but I don't know your whole case. Vishal wants to know his ID on the forums is Prasthak. H4 to visitor visa conversion. The situation is this: he's completing his 6 years. He'll be leaving, but the kids are going to school. So, is it possible that I can apply for my wife and son's visa to visitor visa so they can get 6 months while I'm in India? I think so. I think that's a very good idea. I don't see any problem with it. You should make the case entirely clear to the government and request that they accommodate you. I think it's a reasonable request. So, yeah, certainly worth a shot. Once I'm back into the country with the H-1B extension, can I apply for the petition again from the visitor visa? Yes, you can also have them go to the consulate for stamping H4 visa. Next question is IMI help pre. I don't know what that handle means, but IMI help PREQ. H1B after 6 years and labor pending for over a year. I got H1 transfer to employer A in April 2012 during 5th year of H1B. 6 years would have been done in 2013 March. They applied for H1B with 3-year extension. It should have been only for 1 year, but they got 3 years. However, you also got the stamping for the 3 years, which is incorrect. You should only have gotten 1 year. So not to overstay, you returned within that 1 year that you actually had coming. Good. Employer A had applied for labor in December 2012. The status is still showing as in process even today. Why didn't you get an H1 extension? Oh, I see. You returned to India in Feb 2013 and you would have been eligible for extension of H1 in December 2013 because of your PERM pending. Can I come on my current visa which is valid till Feb 2015? I don't think you should do that. Can I come to US apply for new H1B? I don't think you should do that. There is a strange issue here which is not very clear, and I don't think anybody knows the answer that clearly. I think you can be exempt from the H1 quota, and you should go ahead and apply for your H1 extension based upon PERM having been pending for 1 year, and then you should go back for visa stamping. That's what I think would be the right thing to do. Consulates are very careful about visa stampings, but again, reasonable people could differ about this. If you wanted to be aggressive, you could use the same visa stamp. I wouldn't recommend it. Okay, so apply for 1 year extension of H1 and get a new visa and come back. Eve 1979, green card holder, US citizen petitioning for stepchildren separated due to abuse. I understand your situation. You've got a green card. You are separated from your abusive husband who is filing for your children. They were 16 and 19 when they were filed for, but he's not going to follow through with the paperwork. One interesting question would be, I am not an expert in this area of the law because our practice is very heavily focused on professional and employment-based immigration, business-based immigration. The effect of violence and what are the nuances, I cannot tell you off the top of my head. The question you want to look at is, start with Violence Against Women Act, VAWA, VAWA. See if there is something there that can extend to children. Because if he was abusive to the children, they may have some independent basis of a green card. And there may be a separate provision for somebody abusing children and for them to be protected under immigration law. Take a look at that. I am sorry, I don't have too much information for you. I can point you in the direction you can go, but I really don't know the answers to these questions. Okay. Next question is, let's see. Yesenia, child born abroad to a US citizen. Yesenia is a US citizen born in LA, was in the US until the age of 13, moved to Mexico, just came back a few times, gave birth to a daughter in Mexico. Now the question is, can she get a US citizenship? Another issue that I cannot answer the top of my head. The rules for citizenship are quite complex, not difficult, but complex, and I would not be able to answer off the top of my head. Again, at least I can point you in the direction you should go. what you do is contact a local congressman, US congressman, anywhere. You can contact an LA congressman and ask them to find out that for you. Your question that you're asking me, ask them to find out. They should be able to get you the information quite easily. That way, you don't have to get a lawyer and don't have to waste time and money. If there's something gray, something still not comprehensible, then you can go get yourself a lawyer. Or even we can look it up for you. But at this point, I think it may be a good idea to approach a US congressman. Next question is from Aki03 regarding green card, effect of job role and wage mentioned in PWD. Your questions can only be addressed adequately by the lawyer who is doing your green card process. Okay. There are so many variations to this theme. Your role was programmer analyst, and your prevailing wage was filed as a perm process for software engineer team lead. It got approved with a very high salary, almost double the wage you're getting right now. All of these things are very strictly fact bound. First of all, if you want to go for EB2 in any IT related position, you are likely to get a level 4 wage. Likely, not always, because the government sometimes doesn't follow its own law. If they were to follow their own policy and law, for IT positions for EB2, you would always get level 4 wage. Okay? So, the salary is almost double. Will this create any issue at any stage of green card process? Sure. It can create a problem at the I-140 stage where the employer has to show that they can afford to pay you that salary, and they can do so for each year your green card is pending. If I'm not okay with the current prevailing wage, employer said they can apply as business analyst, which is close to what I'm getting now. My concern is the role has been program analyst. These are such difficult issues to comment upon because I have to know what your job is. In the IT world, a programmer is somebody who codes. The title programmer analyst does not exist in the database anymore. So it used to be. So programmer and programmer analyst is the same thing. If you do systems analysis, coding, and testing, you are a programmer, in brackets, programmer analyst. In addition to all these duties, if you do software architecture or software engineering, then you are a software engineer or software developer, as they are known under the current system. So, everything of the full life cycle development except architecture belongs to programmer analyst, and architecture along with everything else belongs to software engineer. Business analyst is a totally different ball game. It is closer to systems analyst. So, it's very difficult for me to give you any good answers without either taking on your case or reviewing your whole documentation. So you need to talk with the lawyers who are doing the case. Okay? And then you have a question about a takeover. There's another company B which was also acquired by the same company X that acquired our company A. My employer is suggesting me to apply green card through this company B. You can do all of those things. If they have different tax IDs, you can do this. And if they merge later on, chances are it will be okay under the successor in interest doctrine. So you can apply for a green card from a different company if they have a different tax ID number. If they merge later on, if the job remains the same and the company takes over your green card, chances are you will meet the successor in interest requirements. But there is more to it. Again, I'm giving you a very quick overview, so you can talk with your lawyers and discuss the details. Okay. Again, your fourth question is very, very vague. I am a programmer analyst. What job title would be appropriate under EB2? And what should be the wage range? That depends upon where you are located. Are you going EB3 or EB2? Oh, you said EB2. Sorry, my mistake. So EB2 is almost level 4. You can try going to FLC, Foreign Labor Certification, FLC Data Center, CENTER, flcdatacenter.com, and look up your wages. Look at the level 4 wages for your county. Bhaskar D, EB2 with BS plus 5 years of progressive experience. I've got a BFA in Fine Arts, which is Bachelor's of Fine Arts from India. Do I qualify for EB2? I do not know if you have a 4-year degree or a 3-year degree. If you have a 3-year bachelor's degree, chances are you will never be able to qualify for EB2 unless you also finish a master's degree. I have a couple of videos on this. You can look them up. I don't know what is safe for you, Bhaskar, because I don't know if your degree is a 3-year degree or a 4-year degree. So if you're on the phone, go ahead and talk to me and I'll talk about this a little bit more. Smita has given a case number. When will I get a second letter notification? No idea. I don't know what you're talking about. Okay. So I think you're talking about some kind of consular processing. We don't know what your case is. If it is National Visa Center, communicate with them. You can email them. You can also call them. Calling takes forever. Emailing may not be a bad idea. IMI Help 2013 wants to know green card through spouse. I'm an Indian national married to a green card holder. I-130 approved. May I know what the next steps are? And can I do the police clearance now? I don't know what the life of the police clearance is. You can address this question to the National Visa Center in New Hampshire. Again, they are accessible by phone or by email. Okay. Typically, if you are already in the United States, you can apply for adjustment of status, Samir. But if you're outside USA, then you have to go through consular processing, which means your file gets sent to National Visa Center, who will then send your spouse in United States certain documents. She will fill those out. They will get sent back to the National Visa Center, who will then forward the file to the consulate. That's the way it works. Okay. Naveen Chikoti, AC21 job title from analyst to leader manager. If the roles are similar, the title is not that important. Same and similar is very difficult to define. I think it's a matter of percentages. If you are still in a technical position, I don't think the fact that you've acquired some managerial responsibilities takes you out of the AC21 ball game. I think you should be okay, because they've used the language same or similar in the statute. Obviously, similar is something less than same. And a natural progression, it can be strongly argued, a natural progression in seniority is not beyond expectation, right? So, but these are my guesses. Unfortunately, we don't have the regulations. Government never took out regulations. So, in the IT language, we have high-level design, but we don't have the code. So we can't really tell how the system will behave. Okay. Aswaram says L1A to H1 transfer. I'm on L1A with employer A since 2008. L1 is good till June 2015. They don't want to sponsor green card. Planning to move to B, who is willing to sponsor H1 and green card in EB2. Okay. Employer B is planning to apply H1 visa in April, so I can work from October. They also want to start my green card along with the H1. I'll be completing 6 years and 3 months in October 2014. I've learned that I can work for a maximum of 6 years in L1, L1A H1 combination, and 7 years in L1A alone. Correct. How can I avoid the max out so I can continue working? And I think your employer is right. Continue working on the L1A until either the perm has been filed a year ago or the perm is approved and I-140 is approved. I can't think of any other way to go. Okay. So that appears to be the only option. SG22, H4 to F1 and F1 to H4 plus any impact on existing green card process. I am on H1B with more than 7 years. My current extension being based on approved I-140 in EB2 category. Wife is on H4. Since she is not able to work, she started going to school on H4. Okay. If she wishes to work, she needs to convert to H1 and then to get a CPT. That is correct. Is conversion from H4 to F1 easy? Hard to say. It depends upon the USCIS officer, adjudication officer, who is reviewing your application. They can make it as difficult as they want to. How long does it take? Typically a few months, 4 to 6 months I would say. Is there any premium processing? No. H4 to F1 cannot be premiumed. How much does it cost? You have to look at form I-539. I-539, see what the filing fees are. I don't know what they are. I think somewhere in the neighborhood of $400 or $500. I'm making a guess. She currently has valid H4 stamped. Will she have to get F1 stamped? The answer is yes. If she comes back, she'll have to get F1 stamped. By the way, she can, instead of applying for change of status, she can go and apply for F1 visa without any processing with the USCIS. If it has to be F1, is the scrutiny the same as an H1 candidate? Again, it depends. It's so difficult to predict. But F1 visas can be denied for almost no reason at all. So I can't really predict the degree of scrutiny. In the future, if we need to convert her back to H4, is it simple enough? Yes. F1 to H4 is very simple. How much it costs? Same as the first time. H4 to F1, F1 to H4 is the same cost, the same form. If the date becomes current, do we need to be careful about anything? Well, I think you should be mindful of the fact that if somebody has a 485 pending, the government has said they don't think that F1 is compatible with the 485 pending. But they've never said, just because I have filed 485, is my F1 automatically revoked? They've never said that. So just be a little mindful of that. Talk with your lawyers, see what they suggest. You can always abandon the F1 and just be on 485 pending status, authorized period of stay. So immigration reform, I have no idea. I mean, as of a couple of weeks ago, since Boehner came back and said, you should follow my tweets. Also, download our apps. We are having a little bit of an issue with the apps. There's some problem with the updation, but we are working on that. There were some server issues. Follow my tweets. They are also on the homepage of immigration.com. I keep everybody updated on what the latest developments in the law are. Okay. In-laws visitor visa. So the question is, if my in-laws want to come, I make more money than my wife does, should she provide the affidavit of support I-134 or should I? And I don't think it makes a difference. Okay. I don't think necessarily having a closer relationship makes a difference. And the amount your wife makes, which is about $58,000, is quite enough actually. Okay. So you can go either way. AKS 341, I worked on the H-1B visa in USA since December 15, 2005 for a total of 59 months. Okay. So what has happened is that he's got 59 months, but it's spread more than 6 years, spread over more than 6 years. The attorney for new employer filed for 3 years and got the approval. He only counted the time I've spent on the H-1B during the last 6 years. This totals to 32 months. December 2005 to March 2009. Between March 2009 to May 2012, you were on student visa and spent 436 months outside, but not totally. Interesting situation. Okay, I agree with you. I don't think. I'm sorry. Let me rephrase that. I don't recall all of the language of HCFR 2 and 4, which applies to your situation, off the top of my head. But I don't think it makes mention of the amount of time, from what I remember. I think it only talks about 6 years. So if you use 6 years, even though you did it over a period of 7 or 8 years, since you were in the United States, never outside, I don't think you're entitled to those 3 years that you got. I agree with you. Okay. What should I do? What are the potential risks for me? The employer will begin the recruitment process to file my green card soon. The attorney has also asked me to withdraw the visitor visa petition. I don't know what to tell you. One thing you can do is have the lawyers research this issue specifically. Even if you have to pay or your employer has to pay a little bit extra, tell them to take a look at this issue that you have unique in your case and make sure that you're not running afoul of the law. If they give you a written legal opinion based upon good research, I think that's the best you can do. Okay? Because they are the lawyers, and if they figure out that's the law, then I guess you're reasonably safe. All right, let's get started with follow-up questions. No new questions. Please note, no new questions, only follow-up questions of what we have just discussed. Press *5 if you have any questions. *5 on your phone. 2 questions, 3 questions. Okay, 3, 4, 5. Okay. Let's get started. Let's start with Missouri. Manchester, Missouri.
Yeah, this is question number 3.
Number 3, did you say?
Question number 6.
6, okay. For some reason your voice is... Yeah, 1 second. Your voice is not very clear. 1 second. Okay, F1 OPT question. 1 academic year. Can we count fall time, which was the time you were on H4? And the answer is no, you cannot. So go ahead, Sam. What did you want to know?
Yeah, actually, we applied in the December for my daughter. So someone says that if it is approved, usually they give the time when you applied, the date, the active date, right from the, so that's what my question.
So what you're...
second one is that...
Yeah, hang on 1 second. What you're saying is, because we applied in December, if they approve the case, it should go back to December. And the answer is, I don't know. In H1s, the start date is always the date they approve the case, not retroactive. Okay. In F1, it certainly makes sense that they should approve it from the date you filed the case, but is that the way it always works? I do not know. You know what you can do? You can call the USCIS customer service. And they will, if they don't know the answer, tell them I want to speak with an adjudications officer. They will certainly be able to tell you. Okay?
And the second question is that if they take in the summer semester, which is very shorter semester, but still it is considered as a full semester?
I think there is again, I don't remember the regulation, same regulation, HCFR 214. I don't remember it off the top of my head, but somewhere in the back of my head, there is a 9-month period there somewhere. So I'm not sure whether the academic year is considered to be at least 9 months, something like that. Don't quote me on this. Do some research on this. You may want to look at anything less than 9 months may not be acceptable. Double check that.
Okay.
Okay? Good luck
Thank
to you.
you.
You're welcome. Okay. I'm going in the order that you guys logged in. So there is somebody from Jersey City, New Jersey. Go ahead, please. Jersey City, New Jersey. Area code 201.
Hello.
Yes, ma'am.
Yes, sir. This is question number 50.
1 second, ma'am. Let me get to that question. Number 15. The prevailing wage determination question where there is a doubt about programmer, analyst, and software engineer team lead. Okay, go ahead, please.
Yes, sir. I'm a programmer and I do programming. So when I apply under EB2, so the software developer or software engineer would be appropriate for me. Like you mentioned, programmer analyst is not listed. I mean, that designation is not listed, right? So what would be the appropriate title?
Okay.
I'm software developer.
If you have heard my description of the 3 jobs, which you have, it really is very difficult for me to say what you should be without looking at your whole case. And by the way, you're talking to the wrong guy. You should be talking with your lawyers. Because remember one thing, your green card title and green card job can be completely different from your H1 job. So if today you are a software engineer or a developer, once you get the green card, there is nothing in law that stops them from putting you down as a programmer analyst. Or if today you are a programmer analyst, there's nothing in law that stops them from putting you down or giving you the role of a business analyst or a software engineer. So really, it's something that the lawyers have to plan with you. They should be looking at the employer's tax returns to make sure the employer has the money. And before they even filed the paperwork, they should have known that this is going to come as a level 4 wage as a software developer. So really, before even filing, they should have known that this is what it's going to come out as. It's quite obvious.
Okay, so what is the minimum wage level that an EB2 level 4?
I said it's an impossible question to answer. It depends upon your job description.
Okay.
It depends upon where you are working. The county where you work, you have to go to flcdatacenter.com, enter the state where you are working, enter the county where you are working, enter the title you want, and then look at the wages.
Okay.
Nobody can answer this
So
question.
Okay. Like when my company has been acquired by another company, and there is one more company, just like our company, it was also acquired by the same. So there is one common parent company. So my employer, like I mentioned, he asked me to apply GC to the other company. So my question is, once I apply to GC with this company, and down the road at some point it says, for me, a single company, I need to go for any amendments thereafter or any, is any issue with that?
Almost certainly you'll have to do an amendment unless the 485 is already filed. And it's a very difficult question for me to answer. I said I can point you in a direction, but I can't answer the question. Look at the criteria for successor in interest. Successor in interest. It all depends. There are so many variables that I can't answer that question at all.
Okay. All right, sir. I'll check with my attorney. Yeah. Thank you so much.
You're welcome. Good luck. Okay. North Carolina. North Carolina.
Hello, sir. This is Naveen. Question number 19.
1 second, Naveenji. Let me get to 19. Let's see what's going on. You are going from analyst to leader manager and job title under AC21. All right, Naveenji, tell me what can I do for you?
Right. Yeah. So basically, my job, the current job is going to end as of end of this month, and I'm still waiting for the offer letter from the new company. So if I don't get it by before my current job terminates, does it mean I'm going to be out of status?
No. Because you have a 485 pending, you cannot be out of status unless you work without authorization. Okay? So hang on. Let me clarify, Naveenji. I have a couple of things to add to this. See, the law requires that only when there is an RFE and USCIS says, hey Naveen, we want to see an employment letter, only then you are required to produce an employment letter of existing or future employment which is same or similar. And typically they give you, I think 6 to 8 or 10 weeks, something like that, to respond. So you'll have plenty of time. If in the meantime you have been sitting at home and watching soap operas, perfectly fine.
Okay. If I were to mention that, currently I'm using H1, I'm on H1, but I'm planning to invoke my EAD and H21 for the new job. So does it change the situation, or do I need to inform my current employer that I want to switch to EAD?
The only thing it changes is that if you are not working, H1 is gone, but you are protected by the pending 485. And you are given the right to work, you are given the right to work by the EAD. So no problem. Let the H1 go under these circumstances.
Okay.
All right.
Thank you, sir.
You're welcome. Good luck, Naveenji. Okay. We have, let's see. Oh, still 5 more hands to go. Okay, no problem. California, go ahead please. Campbell, California.
Rajiv, this is question number 23.
23.
If you can refer that.
One second.
This question is about the 3-year approval of H1B, although I'm only eligible for 13 months.
Right. I saw that. That's a very interesting situation.
And I have summarized my question at the end of the post that I had made in 2 parts, part A and part B.
Right.
So I have communicated to the attorney that I believe I was only eligible for 13 months, and how come you applied for 3 years? And he says there is no error or mistakes, there is no need to file an amendment at all.
Tell them to that's what I said. I think they are wrong, but I haven't researched this issue specifically. From what I recall, I agree with your analysis. It's interesting, and that's why I like working with people like you, smart people, who are on the ball. You guys go look up the law. While I'm sorry to say that most of you have not taught me much. But every now and then you do teach me something which I love learning, and your lawyers should learn from you as well. I think they are wrong. They should look at the law, and if indeed you and I are both wrong, they should tell us why. Okay? Because the potential risk to you is this. Government has said, if somebody takes advantage of our error, we can deport them. And if we deport them, they can't come back for 5 years. But where a lawyer has given you an opinion in writing that they have done everything by the book and they are right and this is not a problem, I don't think anybody is going to deport you. And I don't think you have that much risk at that time. So that's my guess. If I were you, unless you're willing to change the jobs and just leave at the time that you think is your 13 months are over, I would get a written opinion from them. And I'll tell you this, they may not be able to give you a written opinion. Okay?
Okay. All right. So I would definitely, in fact, the attorney of the employer has responded to me over email that he has not made any mistake and there is no error in what he has done by requesting 3 years for my H1B petition.
What you should do
between me and the attorney.
What you should do is, you should go ahead and state that you spoke with me, and I agree with you. It looks to me like there is nothing in the regulation. Again, I haven't looked at the reg. I think there's nothing in the regulation that says the 6 years of H1 must be in the last 6 years. It just says 6 years of stay. It doesn't say how many years it can extend over. As long as you've not been outside USA, you've got a problem. Okay? So tell them, let me summarize this situation for you. And this is the situation. Can you please confirm for me that indeed this is legal for me to do? And if they then confirm it, I think you are as safe as you're going to get.
Okay, all right. I would take it this way. If you have another 2 minutes, there is a second part to my question.
Sure.
And that was my previous job ended in Jan second week of 2014, and the new employer's attorney filed for my H-1B in the fourth week of Jan 2014. So I had filed for a visitor visa petition on the last day of my last job to remain in a lawful status. But in the H-1B petition, my employer did not include any info about my pending visitor visa and mentioned that my status at the point of time when the new H-1B was filed, I was in H-1B status. And he has advised me to withdraw the pending visitor visa petition as of now. So the complete information was not available to USCIS through the H-1B petition from the new employer. And I'm concerned if there are any problems or potential problems because of that.
Definitely. It should have been revealed to the USCIS that there was a gap in your employment. And if they decide to then, it's within their power to forgive that gap. That's not a problem. But if it's not revealed, they could come back and say the H-1 approval was obtained under an error or even worse, under a misrepresentation. Okay, so I don't like that situation. I certainly think that's something that's problematic. Your lawyer could have a different opinion. I certainly don't agree with them. In my view, unless you make full disclosures, you do run the risk of being hauled up for misrepresentation. Fortunately, H-1 is not your filing. You don't have to worry about it. It is a filing of your employer. But status is a representation about your status. Okay, so you do need to worry about that. Now, what do you do? That's a tough one. That's a real tough one. I think what you can do is call USCIS, talk to the customer service, explain the circumstances, make notes on what they tell you. Date, time, who you spoke with, and the content of the conversation. Okay? If they tell you, look, you've got to do A, B, and C, take it to your lawyers. If they say, oh no, it's not a problem, at least you've done everything that you can. Your lawyer is telling you it's not a problem. USCIS is telling you it's not a problem. If they come after you, we can take them to court.
On a call, do you mean I should call the USCIS on the customer service line?
Yes.
I mean, it will be just a conversation, not any written communication.
That's okay. That's why I said take notes, because under the law, under federal rules of evidence, if somebody is talking to somebody else and they made notes, contemporaneous notes are considered to be good evidence. Okay?
Okay.
All right, I gotta go on. I got a lot of people waiting. I've got to go to the next question. Okay? Good luck. Good luck.
All right. Thanks, Rajiv.
You're welcome. Bye-bye. Okay. Somerville, New Jersey. Go ahead, please. Somerville, New Jersey.
Hey, Rajivji. This is Vishal here. I have a follow-up question on the question I posted today, actually.
Vishalji, what number were you?
I don't remember, but
okay.
It was related to
hang on.
H4 to visitor conversion.
Give me 1 second. I like to have it on the screen so people who later on listen to it can see. Yes, your question number is 11. H4, Prasthak, right? Prasthak?
Yeah, that's correct. Yeah.
Okay, currently on H1B, I'll be going to my home country for a few months. Oh yeah, so family wants to stay here and kids want to go to school. Yeah, absolutely. Go for it.
Yeah, so the follow-up question I have is how much time it will take for H4 to be to conversion actually?
Typically 4 to 6 months, and it's legal to continue to stay here in the United States while you're waiting for a decision.
But they can stay, right? Because my visa is expiring on 20th of April, as I mentioned there. So they can stay, right, as soon as they apply for H4, P2?
They can stay, yes. That's called authorized period of stay.
Okay. And is there any premium processing for this conversion?
There is not. And in fact, even if there were, I would tell you not to do it, because let the government take its time. That way, even if they deny, you probably have already used up the time that you need to for the kids to complete their school session.
Understood. Thanks. And the last question I have is, like, will there be any consular processing once they got the visa approved?
No, because it will be a change of status.
Okay.
Okay?
Okay. Thank you, Rajiv. That was the only question I had. Thank you.
Good luck.
Thanks.
Bye. Oops, what did I do? I just made him a moderator. Give me 1 second. Okay. This needs to be muted. All right, we have 3 more raised hands, and we now go to Jersey City, New Jersey. Go ahead, please, sir.
Hi, Rajiv, this is Samir. First of all, the moment my question was about to be answered, I got pulled up in some meeting for 10-15 minutes, but couldn't really hear that. That was question number 21.
21.
So basically why from H4 to F1 and F1 to H4. So one of the biggest concerns I had was that if we convert from H4 to F1, and can we convert that H4, if needed without issues?
No issues at all.
Okay, sir. And is there any premium processing involved in this? Can we do it in a premium processing way?
There is
normally, how much time does it take for H4 to F1?
No, there is no premium processing. Typically 4 to 6 months. But what you can do is, she can always go to Canada or Mexico, apply for F1 visa and come back.
Okay. But Rajiv, that's something, people are very scared to go outside the country for any visa related stuff. Is it simpler than H1B visa stamping? Because H1B, everybody knows a lot of issues, and people do take it as a last resort. Is it F1 a simpler process?
That's something I cannot really answer in a few minutes conversation. But overall, if the F1 is denied, she still has the H4. She can either come back on H4, and if the H4 is cancelled, she can reapply for the H4 and come back. I personally don't think it's a bad option for her.
Okay. But Rajiv, somebody was mentioning over the internet that, it's possible that when you go for F1, they can take away your H4 also.
That's what I said.
Very weird is it possible?
Yeah, what happens is, technically, under their own processes, if you apply for a visa like F1, before they take your application, they should cancel all existing visas. Not because you've done something wrong, because that's their procedure. But I have not seen them do that in all the cases. In fact, in most cases, they leave the visas alone. Okay. So in the worst case scenario, even if they canceled the H4, she could always reapply for the H4 and come back on H4.
So reapplying H4 is simpler process and shouldn't be involve much scrutiny, and the way H1 people get scrutinized.
I cannot predict that, but I think it's a reasonably safe bet. It's a reasonably safe bet.
Okay.
It's not as safe as it's not as safe as applying for change of status, but it's reasonably safe.
Okay, all right. I think one last thing was that actually my wife did have an H1 also, but that was from few years back, and then because of the market conditions, we converted and due to some personal reason we converted back to H4. So she has an H1, and I figured out that we can reinstate that H1. But the question was that if we go that route, the moment we apply for a reinstatement of H4 to H1, can she start working, or she has to wait for H1 to get approved and only then she can work? Or just H1 reinstatement she is eligible to work?
As far as I know, government's position in this is, unless you are already on H1, you cannot start working based upon a receipt. If you are on H4, you have to wait till the H1 is actually approved before you can start working.
Oh.
Okay?
Okay. But that reinstatement, that reinstatement can happen premium processing, right?
It can. It's not called reinstatement, but yeah, essentially it can be done premium, yes.
Okay. All right. And but in that, that I, of course, I know that, that needs a client letter or some project purchase order or something. But apart from that, does it also need some old service slips like last, if you have an H1?
It shouldn't. It
4
should.
5 years back.
It shouldn't. You don't need salary slips for something like this.
Okay.
All right.
Okay. But obviously she doesn't, she will not go to the quota or anything, so she can get her status back. Okay. Okay. All right. Thank you, Rajiv ji.
You're welcome, Ji. Good luck. Okay. Let's go to Westwood, New Jersey. Westwood, New Jersey. Go ahead, please.
Hey, Rajiv, this is Sharda.
Ji.
And my number is 12.
12. One second, Sharda ji.
Sure.
H1B after 6 years, labor pending for over 1 year. You're in India, planning to come in March. Okay,
Yeah.
Go ahead.
That's right.
And I told
So
you.
what I wanted to ask is,
Yeah, go ahead. Go ahead.
I have about 30 days recapture period. So can I come and use that 30 days and apply for new H1 based on 1 year labor pending?
I think you cannot use that H1 because it was given in error.
Correct, okay.
Okay?
So even if I have those 30 days left?
I don't know what to tell you.
Okay.
You said you have 30 days left from the original H1?
Correct. Yeah, the 6 years is still not complete. I still have taken about 30 to 40 days remaining, so that in case I need it, I can come back.
Hang on, that may work, Sharda ji. 1 second, let me think about this. So out of the original 30 years, 6 years, you've got 30-40 days still left. You've got a visa stamp already, even though it is for more time than was allotted to you. It's not illegal to use it.
Yes. Right.
When you come back, will your employer put you on their payroll almost immediately?
Yes.
Yes, ma'am.
Yes.
I think you can come back. I think you are okay.
Great. So when I come there, I can apply for H1 based on 1 year petition.
1 second. Let's just see.
1 year labor pending.
Your labor was applied in December 2012. That means you were eligible in 2013 December. And now we are in. Yes, absolutely. No problem.
Wonderful. Great. So this labor pending is, they always say that you have to apply in 5th year and not in 6th.
Now don't Sharda ji, don't get into all this. There's a whole history behind that. You're fine. Come on in, start the payroll, apply for H1 extension. You're fine.
Wonderful. Thank you so much, Rajiv.
You're welcome. Good luck.
Thank you very much.
Okay, sorry I cut you off. Going on to the next one. Jacksonville, Florida. You are the last raised hand, then I'll take some new questions. Go ahead, please, Jacksonville, Florida.
Yeah, hi, Rajiv. My question number is
10. Arpit Shah.
Yes.
Oh yeah, the company actually, what a lousy thing to do. They're trying to cancel your green card, huh? They told USCIS that you left before 180 days. So yeah, I don't think it's gonna be a problem. Tell me what are the questions you have?
My question is that, as I said, item 4085 is pending. And actually, there was a query open, and the query was the same thing. And company A submitted that I resigned, and they submitted that you left the company. So they raised the query, we replied, we respond in that query. We also submitted a response from company A stating that he did not resign and he worked for 180 days.
Okay.
So query, we have not received the query response back. And meanwhile, we got automated I-140 revocation email.
I don't see any problem. I still don't see any problem. Did you submit an AC-21 letter?
No, I did not. That was my next question. I mean, when I changed the company,
I think you should do it right away. Do it tomorrow.
Okay.
Okay.
Okay, what I should do? Write a letter saying that I changed the company in this date.
Please. Let your lawyers handle it. Not something you should do yourself. Okay.
Okay, got it. I'll talk to my lawyer to do
Yep.
it. Now, the one more question I have is that my EAD is expiring in June 2014, and my 485 still pending. I-140 is revoked right now. So, am I going to be out of status after June?
Not at all. What happens is 485 pending gives you quote unquote status, which means it's actually authorized period of stay. You are never out of status as long as your 485 is pending. EAD just gives you the right to work. You should not work if the EAD has expired and you don't have a new EAD. Okay. So yeah, no, you will not be out of status. No worries.
Okay. So after June, I will not able to work.
So you should apply for an EAD. I think they're doing it like 120 days ahead of time.
Oh, okay, so I can reapply for
of course
again.
Of course. Okay.
Got it. Okay.
Good.
And that is for both for me and my wife, right?
Absolutely.
Okay. And one last thing, I read some forum online that the employer is doing like this illegal denial. So it's important that you notify your senators and congressmen and report that.
That's
is it a requirement or is it just
complete nonsense?
Okay.
Absolutely and utter nonsense. Okay.
So I should not report to senators or congressmen, right?
They are not watchdogs over these kind of things. It has absolutely no relationship with anything. It's nonsense. I gotta go.
Okay. So
good luck. I have to. You're welcome.
Thank you.
Okay, guys. Any new questions, anything at all, please press *5 on your phone. Any new questions, anything at all? Two people have questions. All right, guys, make sure you raise your hands because I'm only answering these 2 questions and I'm done. We are a little bit over time, but that's okay. I want to make sure I answer these questions. All right, so let's start with, I can't tell, this is New York. I think it's Westchester, New York.
Hi, sir.
Hello, sir. Go ahead.
Hi, sir. My question is number 22, I think.
Oh, okay.
Do we still research?
22. I thought these were, oh, no problem. Let's take a look at it. Oh yeah, in-laws, should you sponsor or your wife sponsor? Go ahead with your question, please.
Yeah, you said that either one is okay. And another part was 134. I did mention that we can put combined income in there.
Why not?
Does it matter or no?
Why not? Why not? Because you'll be, I'm assuming that you are filing your tax returns jointly, right?
Yes.
You should answer all questions on the form I-134 accurately. If they relate only to the individual, okay, mention only the income of the individual, but you'll be providing copies of your tax returns, joint tax returns. So it's all the same thing anyway.
But it was not clear.
I said you will be providing copies of joint tax returns. That should be okay.
Okay.
And in any case, even 58,000 is more than enough for sponsoring.
Okay. And one more question is, she's pregnant now. Is there anything we need not mention unless as or anything like that you sometimes say?
That depends. I personally am always of the opinion you should answer the government truthfully, but you should not tell them the story of your life unless they ask for it. That should be the general rule for everything. Okay. We've nothing. Also, nothing to hide.
We did not mention.
Yeah, nothing to hide, but at the same.
We did not mention to our parents.
Right.
So they can say that they don't know about it too, right? We did not mention it to them yet.
Mention what?
About she being pregnant, so they're not lying anything, but we didn't tell them.
If you haven't
Would
told
that be
them,
okay that if they say they don't know about it, if they ask?
you haven't said this in your question, so it's new for me. That's a totally different situation. Let me think about this for a minute. First of all, is this the first baby you're having?
What's that?
Is this your first
Yeah,
baby?
yes, sir.
Okay. Here is the problem. This is a two-edged sword.
Mm-hmm.
We have to be careful with this. First of all, I think you should tell them that she's going to have a baby, because the government could create problems if later on somehow these facts emerge. It sounds too much like something we are making up. Okay. So I think you should reveal it, but it should not be necessarily the basis for their visit, because they are not going to stay here for 8 or 9 months. They're only going to come for 5-6 months. Okay. They should know, but the reason should be tourism, which is what I hope it is. What happens sometimes is when you talk about daughter being pregnant, some of the government officers, not everybody, take the position, oh, it looks like you're going to become a caretaker of the baby and you're taking away an American job. So as you inform them about the fact that she's pregnant, you should also make it clear that mom, dad, understand, you are not coming here to fulfill the role of a caretaker. You are coming here for moral support. And you're not going to do anything more than what normal parents in the United States do. And in any case, your intention is not to stay beyond 6 months. If these 3 things are kept in mind, I think it will be a good way to go. It's a judgment call. I think that's the way I would do it.
So, but don't mention anything of the past, right?
Of course not. Of course not.
And we did not mention it in any letters or anything, right? Like the sponsorship letter or anything.
Actually, neither a sponsorship nor a letter is requirement of any law. Okay, they can just go apply for a visa, and if they are asked, I personally think that the fact of the pregnancy should be revealed, I think, but that's something they found out later after they had already made their plan. Right? So I am not so sure that should make any major difference. It's a tough call. I'm inclined to disclose the pregnancy. That's what I'm inclined to do.
Disclose what?
Disclose the fact of the pregnancy. Okay. I don't think you should send a letter. I don't think it's needed. I don't think you should send an affidavit of support. They should say visiting daughter and son-in-law in the United States and tourism. That's a good reason. And if they are asked any questions, they should be able to answer about pregnancy. Okay?
Cool. Thank you. Thanks a lot.
You're welcome. Good luck. Okay, last question is from New Jersey, New Brunswick. Go ahead, please.
Sunil Gupta.
Gupta, you don't have to tell your name, but go ahead, please.
Yeah. I have a question of this you by mail also, that my son got married to a girl, son is a US citizen, she is on B2.
Okay.
And then he filed for I-130 in August 2013.
Okay.
They were married in June 2013.
Okay.
And he did not file for adjustment of status at that time.
Okay.
And now he had to go for some urgent work for 2 months and came back also on B2.
Okay.
And the officer stamped time stay limited.
What did they stamp? I'm sorry. What did they stamp?
Stay, S-T-A-Y, stay limited.
Okay.
Limited stay.
All right.
That's it. And now he's going to apply for I-485 along with I-765 for adjustment of status.
Hang on one
Is it
second.
okay that
Hang on one second. I think it's a very, very bad idea. If you go to immigration.com, our website, and take a look at a column right on the front page, there's a column about cases, sample cases from our files. I have talked about a case, there's a video link also, where somebody entered on a B2 visa and tried to adjust status, and it became such a big problem because government said that is fraud. In this case, it can be fraud twice, because first time she entered, she got married, second time she entered using tourist visa again with an intention to do adjustment of status. I think, Mr. Gupta, this is a very, very bad idea.
Okay, then what exactly you suggest or something?
Consular processing. So let her go to her home country, not stay here, go back to her home country, wait for her green card there. Okay?
So I-130 should be approved because he is a US citizen. It will be approved as soon as it is, the visa is available as soon as it is approved. I-485 is not a good idea at this stage.
No, I think that can be construed as fraud. Read my note and watch the video. It explains to you why. Okay,
it should be on your website itself.
Yes, it's one of the sample cases. Last 2-3 cases we have, and it was a very big problem. We had to work very hard on winning that case. So that was such a problem because the lady entered on a B2 and filed for adjustment of status. Government gave them a hell of a time. Okay. Good luck. Good luck, Gupta ji. All right.
Thank you very much.
All right, guys. I'll see you guys in 2 weeks. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.